From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court fails to find the leaker of the draft Dobbs abortion ruling as new figures show that the unionized share of the workforce has fallen to its lowest level on record. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnist Kim Strassel and editorial board member Monet Ukwe-Barua. Welcome, happy Friday to one and all. The leaking of Justice Samuel Alito's draft decision in Dobbs, the case that overturned Roe v. Wade last year, shook American politics. It apparently also prompted an unstable man to show up in the middle of the night outside Justice Brett Kavanaugh's house before he turned himself in. He had a pistol, ammunition, zip ties, a crowbar, and other such things with him. But Kim, it seems after months and months of investigation, we are no closer to figuring out who done it, who leaked the draft. On Thursday, the court released a 20-page report by the marshal of the court, Gail Curley. And Kim, I wonder if a place to start would be to give us a sense of what this document says.
Yeah, it basically says that they feel as though they have pursued pretty much every avenue that they could. They interviewed most of the personnel at the Supreme Court. Many of them signed documents attesting that they were not the leakers. They went on social media to chase down leads that had been crowdsourced on there about what potential clerk it could be, and they didn't come up with anything there. They did discover, I think, what we should consider one good piece of news, which is that they're fairly confident that this was not the result of an external hack, which I think is important because there have been some cybersecurity attacks on the court system, and being able to rule that out and knowing that the system looks to have been durable enough to have repelled anything like that is good news. The bad news is that despite all of these interviews, all of this chasing down, they feel that they cannot find the person who did it. Now, there's potentially some holes in what they did do, but it's a little worrisome because it sounds as though maybe they are just going to be finished at this point and that we may not have an answer.
I'll pick up on the point that Kim made about having court staff sign these affidavits. And I think this is important because one of the questions when the leak initially happened was whether this was against the law, whether court staff would be breaking any sort of law. I mean, obviously, if they had leaked something, they would be breaking their obligation, their employment duties, but whether that would be a prosecutable offense. And so it is notable that the marshal says that each employee was asked to sign an affidavit under penalty of perjury, affirming that he or she did not disclose the Dobbs draft opinion to any person, did not disclose to any person information relating to the Dobbs draft opinion. Also notable, Monet, that it says a few of those interviewed admitted to telling their spouses about the draft opinion or vote count, so they annotated their affidavits to that effect. And then the marshal adds that if investigators later determined that any personnel lied, those personnel would be subject to prosecution for a false statement. And so, Monet, I mean, that I think is notable because it suggests that at any time, if the leaker is discovered, that they would be subject potentially to that prosecution, which suggests that there may be a long wait here. We may never find out who this is, or it may be a deathbed confession. I mean, how many decades did Watergate fans have to wait to find out the identity of Deep Throat?
Exactly. And to Kim's point, I completely agree that you would hope that the probe still continues, even if the formal part of it has now closed. They certainly shouldn't accept merely having the denials of everyone with access to the document and doing a quick forensic check and then wash their hands of it because it was so important. The impact that the leak had, they definitely want to make sure to discourage behavior of that kind in the future. And so it was useful that everybody did swear that they neither participated in the leak nor had any knowledge of it. Hopefully, attaching a potential penalty, as you said, the threat of perjury, would discourage people from making a similar type of leak in the future, knowing that if anything gets out, they're going to be subjected to an internal investigation and then forced to swear that they were not involved in it or confess. But I think retroactively, it would be very, very important to find the perpetrator here. But the focus should be on conducting an investigation in the most thorough way possible that will discourage similar leaks of Supreme Court draft opinions in the future.
But one lesson from this, I think, Kim, is how difficult these kind of leak investigations actually are. And maybe there are some trails that the Supreme Court did not go down here. I mean, there is a note in this document that this is a public version of the Marshall's report. But as far as I know, there's no indication that the FBI was brought in to do forensic analysis of people's cell phones and stuff like that. I mean, they did do some of that, but not at the level of a real law enforcement agency, it seems to me. And Kim, unless you're going to do that kind of stuff, I think it's very hard to find somebody in an organization, if they work hard to cover their tracks, when they're doing something like whisking a document out the door and handing it over to a reporter.
Exactly. You would think, given the relatively narrow world we're talking about here, that this would be easier to do because, we're not thinking of the entire vast federal bureaucracy in the executive branch or the thousands of people who work in Congress. This is a group of people that is less than 100, at least in terms of the numbers that they interviewed in the end and who they felt would be most possible to have done this. Now, I appreciate that the Supreme Court is potentially a bit wary or reluctant to invite the executive branch like the FBI into its affairs. But I do think it's going to have to think very hard that if it's not going to do that, about maybe bulking up its own capabilities to protect against this happening and making it clearer that it will be tracking and taking care of things. Now, one thing that a lot of people have mentioned is the possibility that this is something very unique to this period of time, in that normally the Supreme Court has this internal system. It's not connected to the rest of the internet. It's very walled off. But some procedures were changed to deal with the need to work at home during COVID. And so there's some question as to whether or not that played into it. There's also some really outstanding questions out there about whether or not even this probe, with the tools they had, was extensive enough. For instance, one thing that's not clear in this report is whether or not the Marshal and her team interviewed the justices themselves. Now, some people might suggest that there's a sense of decorum there, that perhaps it's, too much to even suggest that any of them could be the leaker. But, I think everyone deserves to know what exactly was the Marshal's approach to the justices. I think another thing that is getting some attention, that is potentially also a question of whether there was a gap here, is while they did ask employees about their communications with their spouses, it's not clear that any interviews of spouses and partners were conducted. Now, again, perhaps the Marshal doesn't have that ability to require civilians to come and submit to a discussion. Maybe that's why they didn't go there. But did someone bring something home one night with all intentions of keeping it safe, but somebody that wasn't as trustworthy threw it out there?
The other takeaway for me from this report, Imane, is the court's protocols. And as Kim says, this seems like it shouldn't be a huge investigation. We're talking about fewer than 100 people, and yet 100 people is a lot when you're trying to narrow this kind of thing down. And the Marshal explains that the draft opinion in February was first emailed to a distribution list with law clerks and permanent court personnel on it. There were 70 unique users on that distribution list. Then in March, it was sent to another 8 users. A couple of other personnel accessed it at some point. So there were 80 people who had electronic copies of this draft opinion. 34 people confirmed that they printed out copies. 4 people were unsure whether they printed it out. It also says many printed out more than one copy. And so, Monet, you have to imagine that the court has taken a close look at its systems and how these kinds of opinions circulate. But a distribution list with 70 people on it and 34 people printing out copies and people not remembering if they did or not and how many copies they printed out, especially when you're talking about something as sensitive and politically explosive as overturning Roe v. Wade. I mean, in retrospect, it's kind of amazing that that is how the opinion was being handled internally in the court.
Yes, and it's also amazing that we haven't had a major leak of this kind long before, given that presumably these protocols had been in place for as long as the system has been digitized. I do think that it's sensible that there were a large number of people with access to the draft opinion. Once the justices are writing their opinions on any given case, They then need to revisit it, and that's how sort of the dialogue begins within the court that leads to the final opinions, dissents, concurrences, etc., and clerks are involved in that process. So in some form, it makes sense that there's going to be a fairly large number of people with access to any draft opinion. But I do think it's sensible to say that you want to limit digital access, make sure that people don't have transferable and copyable versions of it, make sure that people are doing as much of their work on it with hard copies in monitored office space and things like that. And I don't know whether the report was very thorough about what kinds of reforms might be coming down the pipe. That might not have been the focus of the report that we've seen, but you would only imagine that they're thinking about ways that they can tighten it up without restricting the necessary access to the documents.
But there are downsides to those kinds of restrictions, too. The Associated Press reported yesterday, it says the Supreme Court has never been so slow. For the first time, the justices have gone more than 3 months without resolving any cases in which they heard arguments since their term began in early October. And the court hasn't addressed this. There are many theories for why this could be, but one of them you have to wonder, Kim, is whether the tightening of these kind of protocols means that the justices are being more circumspect when they're authoring these draft opinions, how widely they're sharing them, how much help they're getting on them from professional court staff and law clerks. And I can only wonder whether and how much this is slowing down the day-to-day business of running the Supreme Court.
And it's a problem because the Supreme Court obviously is the highest court in the land, and every year it is faced with the possibility of thousands of cases. It has to choose very wisely which ones it will settle because it knows that it has a finite amount of time in its sessions each year to get these done. So any further slowing down the process is, in essence, kind of justice denied in that it's not allowing the court to maintain a roster of cases necessary to keep up with what's being pushed at it from the lower court system. And that might bring us to think about other ways of going about this to try to dissuade these kind of leaks from happening. Yes, you want a tightly run ship in terms of information technology and procedures within the Supreme Court. But one other idea that was floated yet again today, I see that Mike Johnson, who is a Republican from Louisiana, last year he introduced legislation called the Leaker Accountability Act. It would, for the first time, expressly prohibit the disclosure of a court opinion. Those who broke it would be subject to a fine or up to 5 years of imprisonment. Interestingly, the marshal in her report actually pointed out some of this legislation that was introduced in response to this and advocated that consideration should be given to supporting such legislation. Because as we talked about, obviously, there are crimes about putting out sensitive information. Obviously, the marshal has put everyone on notice that they could potentially be in trouble if they lied in the course of this. But there isn't necessarily a law expressly prohibiting this particular action. And perhaps getting that over the finish line would send a note to those who are working on this that there will be consequences if they break the rules.